Are you Wayne Cummings? Mr. Cummings, the best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. And so this is cause number 18-29640. Mr. Cummings is on probation for the offense of manslaughter. A motion to revoke community supervision has been filed, and Mr. Kimler's filed a motion asking that I set a bond. Looks like the date of the probation was from October 22nd of 2018. A 10-year term in prison, probated for 10 years. New offense alleged in that motion is a driving while intoxicated, October 5th of 2025 in Orange, at a location other than his residence at 4:15 a.m. on October 5th in Orange, and that he was intoxicated on that date and behind in court-assessed fees. Mr. Kimler, you may proceed.
Your Honor, first observation is Mr. Cummings did turn himself in. This wasn't one where he headed for the tall grass when he found out he had an MTRP. He did turn himself in. I understand, I think this is straight probation. He's not entitled to a bond. However, with the Orange, and of course, Mr. Smith is familiar with Orange County. It may be a while before that DWI is filed, so I don't know how long it's going to take for the state to be in a position to try to prove that up. So we were just asking for a bond pending disposition if they're going to proceed on the DWI. Obviously, they could proceed on the administrative violations.
Mr. Smith?
My concern, Judge, is firstly, the manslaughter was basically a DWI where he hit somebody and killed them. He had issues. Safety was a recommendation for the original probation to go through in the PSI. This new offense, the allegations apparently show he was out at 4 in the morning and was intoxicated driving. And so I would have reservations and concerns. I think there's been a relapse, and
we're letting you out, but we're watching you like a hawk with a clipboard. And notice how the judge keeps circling back to address stability, because if you don't have a fixed place to be, GPS compliance becomes a disaster.
he's not actually entitled to a bond because it's a straight probation versus deferred. So we would be opposed to a bond.
Do you know the status of the Orange County case?
I don't, Judge.
I don't think it's been filed yet, 100%. I checked before.
If it was just knowing how they work over there, if it was just alcohol, they would have already probably had the results.
Y'all are just guessing. Is there a way for us to find out? Is there any kind of hold on him? Yeah, let's do real quick, and we'll just do it real quick. Just have a seat, sir. And there's not. I'd like to know what the. Good morning. Are you Marquise Jones? And Mr. Parker, will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Jones, in cause number 21-37263, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation February 23rd of 2022 for the offense of theft of material, and that was a state jail felony, and it was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of evading arrest on June 20th, 2024 in Harris County, Texas. And is that true or not true? And then count 2 alleges that you were at a location other than your residence at approximately 1:30 a.m. June 20th of 2024. And is that true or not true? Did you enter your pleas of true to counts 1 and 2 freely and voluntarily? And did you plead true to those counts because they're actually true? Speak up, please. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
And I think I said your plea of guilty instead of true, but your pleas of true. Anyway, all right, so I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty. And at this time, find you guilty of theft of material, aluminum. I guess it goes on, aluminum, bronze,
Aluminum,
copper.
bronze, copper. They were cutting catalytic converters.
And so find you guilty and sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir, and thank you for being here, sir.
Thank you.
Oh, my nose is sneezing. All right, again, you're Wayne Cummings, right? And Mr. Smith, what did you find out about that Orange County
I
case?
spoke with staff at the district attorney's office. They have not.
Can y'all stop? If you're talking about a case, keep it down. If you're not, please stop.
They have not received the case. Found out the agency, it's Orange Police Department that made the arrest. He said, the person I spoke to said that it normally takes about 6 months to get this done. It's going to be a misdemeanor, it looks like, based on looking at criminal history and his PSI, and they thought that as well.
Okay. So then,
The state is stacking factors, prior felonies, missed court, and jail write-ups, because bond isn't just about the charge, it's about whether the judge believes you'll follow rules tomorrow. And the printer malfunction?
that's really the main issue, obviously, in this motion, out past curfew and that
That was the thing that
offense.
concerned me, was the time of day.
Sure, so here's what I'm gonna do. I'm going to grant the motion to set a bond. I don't want Mr. Cummings driving at all, right? So that's gonna be a condition of this bond. You're not allowed to drive a vehicle ever while you're on this bond. No one's vehicle, not yours, not anyone else. For any reason, you're not allowed to drive. Do you understand? I'm going to set the bond in your case at $25,000. Again, condition of that bond is no driving. Also, a condition of that bond is going to be that you are required to wear a GPS monitoring device at all times and remain. Do you live in Orange or do you live in Beaumont or Port Arthur? Where do you live?
I was in housing out there in Orange.
When you go home, if you make a bond, where's home? Where are you going to be? In
Maybe-
Orange?
Maybe. I'm trying to figure out, I don't know where I'm gonna go.
Okay.
I can get back with you on that.
So what I'm gonna do is require a GPS monitoring device and that you remain in either Orange or Jefferson County. You need to let your bondsman know they're gonna require an address so that I know where that GPS is you're supposed to be. And obviously, you're still on probation. The same curfew applies. You're not to be out of your house past 10 o'clock at night. And also going to require I think it's probably because I'm requiring the GPS, a little more cost effective to do the handheld breathalyzer. So you're going to be required to have the handheld breathalyzer. You are not to drink alcohol ever. If you test positive, if you miss blowing throughout the day, it's a thing where you have to blow randomly throughout the day. It's going to tell you when. Probation and your bondsman can go over that with you also. But if you test positive for alcohol, your bond's going to go right back up and you'll be back in jail. Do you understand?
Yes.
If you need some help, you're still on probation. Go to your probation officer. Say, look, I relapsed. I was drinking. What can I do while you're out on this bond if you make it? Okay? Anything else?
You have to report to probation.
Anything else?
No, ma'am.
Anything else, Mr. Smith, that you can think of?
You have to report to probation.
Okay, you can go back with the bailiff. All right, sir, you're Michael Brasher. And this is 23 DCCR 0944. Mr. Brasher's case is set for trial to begin with jury selection next Monday. And what is the announcement?
State's ready for trial.
All right, then this will be the number one case. There was only two or one really left over from yesterday. And so I can go ahead and let y'all know it will be the number one case. After today, there will be no plea agreements. If something gets worked out before you leave today, let me know. Otherwise, we'll see y'all Monday and we'll begin jury selection at 1 o'clock.
Yes, ma'am.
All right, thank you. You can go back with the bailiff. Good morning, sir. Are you Michael Victoria? And this is cause numbers 21-36410 and 21-36411. Mr. Victoria is charged with murder in each of these cases. Mr. Matusko, what is the announcement?
Your Honor, at the last setting, I informed the court that it had about 48 DVDs in this case.
Right,
This morning I checked, I'm on 23. I'm about halfway there. And that also includes hundreds of documents I've gone through. So I'm getting close, but I would ask for one more regular recess.
Mr. Smith?
Judge, I completely understand this is almost a bucket just with the two cases. So.
Right. All right, so I'll do a normal reset to give Mr. Matuska some time to complete all of that discovery, come out and visit with you about it. We'll see if we can get an announcement at the next court date possibly. Okay, you can go back with the bailiff. We'll take a look at it real quick. So, sir, are you Calvin Hawkins? And this is 24 DCCR 1160. Mr. Hawkins is charged with unlawful possession of a firearm by a felon. Looks like the bond is currently set at $100,000. There was a court date, March 31st, that Mr. Hawkins did not appear, and so there was a bond forfeiture, and the bond was raised to $100,000 at that time based on that. And then Mr. Macon looks like was hired, filed motions and letter of representation in October. So here is Mr. Macon, the state's. I don't know why it's printed like this. Oh my gosh.
That is the judge slamming the brakes on a defendant who's about to talk themselves into a worse situation. Courtroom survival tip: once the ruling is made, arguing in the moment usually doesn't help. It just creates sound bites the court won't love.
No, I mean, I printed 2 copies and it printed like 1, 1, 2, 2. It hasn't done that in the past, ever, when I've never seen it do that. It never has done it to me. Okay, so the state filed a reply to Mr. Macon's motion asking for a bond to be reduced. Let me take a look. Go ahead.
Just a summary.
Yeah.
Page 2, it's refers to the defendant's criminal history, and also on page 2, the very bottom refers to jail write-ups, and that's essentially the state's, what the state would ask the court to take into consideration if you are so inclined to reduce the defendant's criminal history, including 4 previous felony convictions, 1 for burglary, a felony theft, the possession of cocaine, and a felony marijuana. And he's been also written up by jail staff for possessing contraband in jail and failing to follow and disrespecting the rules and staff in the jail.
All right, thank you, Mr. Coleman. And I am getting copies of any jail incident reports.
I've attached a couple of those reports to my motion, for my
I s-
reply.
Oh, okay, I see those. Would you check and see if there's anything since December 3rd? So the all of those offenses, the burglary, theft, possession of cocaine, and felony possession of marijuana, all of those are felony offenses and convictions, correct?
That's my understanding.
Mr. Macon, you may proceed.
Yes, Your Honor. First off, Mr. Hawkins, you're unable to make the 100,000.
Hold on just a second. Raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead. I'm sorry, Mr. Macon.
Could you state your name, please? And you've been unable to make the $100,000 bond, correct?
Yes.
Okay, do you have family and friends that were a reasonable bond be set that you could make?
Yes.
Okay, now you understand you're from Florida, so if you make a bond, you'd have to stay in Jefferson County.
Yes.
And you have friends that you would live with here in this area?
Yes, sir.
Okay. Now, you turned yourself in once you learned there was a warrant for your arrest, didn't you?
I didn't know I had a warrant for my arrest, but
But when you learned, you turned yourself in.
yes.
Okay. Do you understand that you also would be required to wear a GPS monitor and probably a drug patch or anything like that? You would comply with all those conditions. And whatever other conditions you were given, you would do. Okay, now, with respect to this contraband, the September 26th, they were Tylenol pills, right?
Yes. I just didn't take it.
You were given them by the jail staff and didn't take them. Then December 3rd, and December 3rd incident was you having your jumper down or something.
Oh, man.
But you didn't have a knife or anything like that or anything like that. In other words, they wrote you up for refusal to follow written or oral directives. But you didn't jump anyone or beat them up or anything like that.
No, I don't even recall that write-up. I didn't know it.
Okay. I have nothing further on it.
Okay, I'm reviewing the probable cause as well. Is there anything else, Mr. Macon?
Your Honor, Damashi, and I'm probably mispronouncing this. Damashi, is that how you pronounce that? Demisha Jones is a witness who's going to say the gun was hers and she put it under the seat.
It's not what she told the officers that day.
And that's what she's going to testify to anyway.
Okay. So for the record, I have reviewed the probable cause affidavit. I also did receive notification, and if anyone has questions for the bondsman's representative is here today. And her company had to hire a bounty hunter to locate and get Mr. Hawkins after that bond forfeiture. So obviously, to me, that would indicate that he was not keeping up with his bondsman, and otherwise he would have, if you bond out, you got a bondsman. You check in once a week, you would know you have a court date. If you miss a court date, you would know there's a warrant. So there's that issue as well. Mr. Coleman, what's the state's position?
The only thing I'd add, Judge, is that he's subject to a habitual offender enhancement, making him $25.99, Judge.
Okay. At this time, based on the nature of the offense itself, the unlawful possession of a firearm by felon, the probable cause affidavit, and the information that was in that. There were 3 vape pens found as well. I know obviously none of this is proven, but it is important to know. Everybody had different opinions, or the 2 of them, about where the gun was, whose it was. They both said it wasn't theirs. And the fact that he missed court and had a bondsman, and that bondsman had to get a bounty hunter to get him back here. And the fact that he's from Florida, was apparently working supposedly in Louisiana and driving through here to sightsee in Houston when he was arrested, gives me concern about all of that. And so at this time, I'm going to deny the motion to reduce the bond. The bond will remain at $100,000. I'll reset the case for an announcement, and we'll get it moving in whatever direction it needs to at that time. All right?
I was just wanting to say I was never arrested whenever she pulled me over. I wasn't arrested at all.
When?
When she initiated the pull-over.
But you had a bondsman, so at some point,
That was after I had found out I had a warrant.
right.
And I was keeping up with my bondsman. I texted her and said I was trying to.
Here's the thing, she's here, so be careful what you say. I've already made my ruling. You can go back with the bailiff. Oh, you're good. That's okay, sorry. All right, sir, you are Larry Fitzgerald Williams.
Yeah.
And so let's go off the record for a second. Mr. Cashin?
Your Honor, first of all, I want to thank you for allowing me to appear by Zoom. I don't want everybody to know about my health condition, but I just recently underwent a major surgery. I have staples in my stomach. I can't move, in a lot of pain. But I just wanted to thank you for allowing me to appear via Zoom.
No problem. Yes, sir.
I am recovering, and I should be better in about 30 days.
Perfect. Thank you for Zooming, and we hope you do get better. So at this point, any announcement on Mr. Williams' case?
Right now, presently, we are not ready for trial. We will be ready in about 60 to 120 days. There are some things that we want to get ready. We need to prepare. We need to go through some of the T-Mobile records from the deceased as well as from Mr. Williams. Also,
So here's what I'll do, Mr. Cashin. You don't even need to go through all that. What I'll do is I'm going to reset the case for about 45 days.
Yes,
That'll
ma'am.
give you time to recover, as well as go through more discovery, meet with Mr. Williams, Mr. Johns, whatever y'all need to do. We'll see where we are at that hearing. If you need a little more time with discovery, we can work on it then. If you're ready to reject any offer and go forward with the trial date, then we can do that on that date. We'll just see where you are in 45 days.
that'll be fine, Your Honor.
All right, thank you so much.
right.
Get well.
All right, thank you very much. Mr. Williams, I'll be in touch with you.
Okay.
Good morning. Are you Heriberto Chavez?
Yes.
And in cause number 25, DCCR 0559, Mr. Chavez is charged with deadly conduct, discharging a firearm from May 8th of 2025. What is the announcement?
We signed a rejection.
Oh, I'm sorry. Mr. Chavez, what that means is that if you go to trial and you're found guilty, the range of punishment is a minimum of 2 years up to 10 years in prison. Do you understand?
He understands, Judge, he thinks the offer is too high right now.
So the state, I have on the computer tablet a plea bargain rejection that has your signature on it, that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 6-year term in prison. It says or, but,
I think we've been discussing a possible cap, Judge. I think that's
okay, just the 6 years.
Oh, today was an offer of 6 or the cap, so it was my
What was the
understanding.
cap of what? Y'all-
You didn't write it
I didn't,
on
I'm
there.
sorry, it should be 8.
or a cap of 8 years in prison, which is where you would leave your punishment up to me. I could not give you more than 8. I could give you 8 years. I could give you less. You have an absolute right to have a jury determine if you're guilty or not, and for that jury to determine your punishment if you're found guilty. I want to make sure you understand what the possible consequences are if you go to trial, and what your options are if you wanted to enter a plea of guilty. And do you understand all of that? Do you have a question?
I want to try, but I don't want to accept the offer right now.
Mr. Nichols, is there any reason to believe that the state's offer would change?
No, Your Honor.
So you don't have to like the offer, but the offer is what it is. So your option is either to let a jury decide or to accept that offer. And so what do you want to do?
Wait.
There's no waiting. You have to make that decision today.
Try.
All right, I want to make sure you understand that after today, I won't accept that plea agreement. And do you understand that? Answer out loud.
Yes, after today, you won't accept that agreement.
Okay. Mr. Chavez will get your case set for trial. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial quicker. Is that okay with you?
Yes.
All right, so Mr. Rojas, you're released. Mr. Chavez, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff.